Hello, everyone. I'm Kim Quillen with the Chicago Tribune, and on behalf of CEBU, welcome to today's webinar on copyright and fair use in a digital age. Bernadette Burns is here, and she has put together this presentation, and she's going to be leading us through it. Bernadette is the General Counsel and Corporate Secretary of Radio Free Asia, a private nonprofit corporation funded by an annual grant from the U.S. Agency for Global Media. She has been General Counsel since 2006 and Secretary since 2008. She advises the RFA Board on corporate matters and advises RFA on matters such as copyright, immigration, and labor and employment. Previously, she was the Director of Legal Affairs for the International Committee for Holocaust-Era Insurance Claims. Bernadette started her legal career as a Judge Advocate General with the U.S. Navy. To our listeners, if you have a question for Bernadette today, you can submit it using the chat function at the bottom of your screen or by emailing it to sabew@sabew.org. That's SABEW at sabew.org. And I realize we have a couple of people listening in by phone today, and I'm sure the email approach will be better for them. So we are accepting questions both ways, by chat function or by email. With that, I will hand things over to Bernadette. Bernadette?
Thank you. Thank you very much for that lovely introduction. It's my pleasure to be here today to talk with your group. I don't stray too far from Radio Free Asia, so it's nice to have some new people on occasion. And copyright and fair use is, at least for our organization, it's something that we need to talk about frequently. It changes quite a bit. There's always something new. I also do copyright in some other countries, but I'm going to concentrate today on just the United States and how we work here. So you might notice on the bottom of your screen, which I'm required to do, I'm very happy to present this information to you, but please don't consider it as legal advice. It is intended for educational and informational purposes only. If you have a legal question outside of the seminar, you should consult a licensed attorney in your area. There's the legal mumbo jumbo that's required. So now on to our session. So I'm going to start with the very basics of copyright law, which is the cornerstone of copyright law is protection of original works. These can be any number of things, but an original work is protected as soon as it is produced in any tangible medium. And that can be a drawing, a writing, music, even if you need to have some other machine or device. As long as it is a tangible medium, it's protected. Works are protected even without the copyright symbol. It used to be that if it was first published after 1989. Before 1989, it was required to have protection to have the symbol on it. But even if you're doing anything and you're copywriting it, it's much better to put the C on so that, well, for two reasons. One is it takes away someone's ability, an infringer's ability to say, oh, I didn't realize it was a copyrighted work. So if the C is right there, obviously it's a copyrighted work. But if it was published before 1989, the work is in the public domain. Or if it was otherwise required, and it was not there, it's now in the public domain, which we will talk about quite a bit later. There are 8 categories of protected subject matter which are listed in the Copyright Act. They are literary works, musical works, dramatic works, choreographic works, graphic works, audiovisual, sound recordings, and architectural works. You'll notice that there's 2, musical works and sound recordings, that you might think are similar. We'll talk about that later too, but they are 2 separate copyright protected works, the musical composition and a separate sound recording. And then also, just as a general informational thing, which I found sort of fun when I was going through some of my research, Choreographic works are, of course, protected. Many great dances and ballets. A couple of years ago in California, there was a woman who was trying to copyright some yoga poses that she felt like she had developed. But the judge ruled yoga poses were not really protectable. So stick with your choreographic works if you want to protect them. It is important to remember that facts, concepts, and ideas cannot be protected. How that fact or idea is expressed is what is copyrighted and what is protected. The reason is, facts are facts, and you can't really change many of them. That's why, like a book of statistics or things like that, they do not get as much protection as a creative work in how a fact is actually presented to an audience. For example, what happens at an event is not protected. How that event might be described or depicted in a picture will be protected, because that is the creativity that's required for a copyrighted work. Musical notes are not protected, but how they are arranged is what's protected. The owner of a work, oh, I already did that one, didn't I? Sorry, I got two same slides in there. But we'll go over again. The owner of a work after 1989 does not need to register the work, but registration and placement of the copyright symbol protects you better from an infringer. So now we have in the public domain. When a work of authorship enters the public domain, its copyright protection ends. The exclusive rights provided by a copyright law will cease to exist. And there's a few ways that, works come in the public domain. The first is the copyright is expired. Second is copyright owner, failed to follow copyright renewal practices and rules. He may have had to protect it at one point, and copyright law is pretty technical, so I'm not really going to get into all that, but I'll tell you later how you can check. If it is a copyright that is able to be renewed and the owner has not renewed it, then that too will be in the public domain. The copyright owner himself or herself can decide that it is just not going to be protected and will place it in the public domain. That's called a dedication. If there's an artist that paints a very beautiful picture but wants to have it just enjoyed by everybody, or a literary work, they can do what's called a dedication. And then that is automatically into the public domain just upon its publishing or printing or however it's put into tangible form. The copyright laws do not protect these kinds of works. Almost all works published in the US before 1923 are now in the public domain. And whether they were published in the US or not, many, like from other countries, because of treaties with the United States, are also in the public domain if published before 1923. For example, something like Shakespeare's plays, they are what's called the permission-free zone. Anybody can put on a Shakespeare's play. Anybody can write an adaptation or publish it in any manner they choose. And because that Shakespeare's work is no longer protected. However, once someone does that, their work is protected. They've put on a production or they've done a sound recording of Shakespeare's plays. That particular person now holds a copyright to that production. It doesn't change the free nature of any of other Shakespeare's plays. It only changes, it only applies to that production put on by that particular artist. There's no permission required to copy or distribute other old plays, adapt it into a movie, perform it in public. Once it's in a tangible form, then, as I said, it becomes, that part of it can be copyrighted by the person who has put it into the tangible form. For your purposes, I know it's like business writers, and I'm sure many of you are not just business writers, but what I find very helpful when we're doing stories here is many of the mostly everything that the federal government produces is not subject to copyright. That includes all sorts of things, all their charts, their graphs. You'll see them in, papers, and you probably all use them now. Consumer product information, the growth rate, all of those records that the government spends time and money putting out are free to use for anybody who is actually physically present in the United States. You don't need to get any permission or pay any copyright fees. Public domain applies to mostly everything produced by the government. There's a few minor exceptions, but basically all their pamphlets, all their documents, maps, charts, images, instructional videos, federal statutes. You can use any of those, adapt them, change them. They are all in the public domain. I've put up here what is on the White House website. Most of the other federal agencies have either very similar, or sometimes it's almost exactly this language because it's not copyrighted. They can do that. So it's pursuant to federal law, government produced materials, because they're produced by the government. They're produced by your money, taxpayer money. They belong to all of us. Appearing on this site are not copyright protected. The United States government may receive and hold copyrights transferred to it by assignment, bequest, or otherwise. When that happens, they don't put them out that often without a disclaimer saying this is copyright protected, this was bequeathed to us, or in some other way we got it other than the federal government employee doing this in the normal course of their job. The White House also, and not all the federal agencies do this, but a good portion of them do, require anybody contributing to any website or any page on there that that comes under a Creative Commons license. And I think you're probably all familiar with that, but that basically means it's a non-exclusive, irrevocable, royalty-free license to the rest of the world for any submissions to the White House. So, Creative Commons licenses, if you need things, you can actually find some really interesting things on there. When you're just looking for anything maybe more than a stock photo or some charts that are not available from the government. It's a good resource to look on there. So this is sort of a fun one. Most of you probably remember this monkey selfie a couple of years ago. And it's determined that that is not protected because there needs to be some human authorship required. So just to refresh your memory, this monkey picked up the camera of a wildlife photographer and took his own picture, which it's still amazing to me what a good clear picture it is, because mine are not usually like that. Anyway, it was published on The Guardian and Huffington Post and several other news organization websites. And the owner of the camera the owner of the camera claimed ownership and said it was copyright protected. So it never actually went to court, but the general feeling out there was, and it was accepted by him because it's really a pretty basic fact, that it's not copyrightable without a human author. So after because it wasn't copyrighted, anybody could use it, obviously. So after the photographer, after that, he used that selfie in a book of some of his other photographs. And PETA sued on behalf of the monkey, which was a first for me to see, and I think the court thought as well. They were representing the monkey, saying the monkey had a legal right to that, taking that photograph. It was in tangible form. And the human authorship, he was a monkey. It was, I think, kind of close enough. Anyway, PETA lost at the lower court. And the photographer was actually philosophically very fond of PETA and was sort of surprised at what had happened. So they eventually came to some agreement, and I believe that there was some money exchange. So it all turned out well. but that's important to remember. There needs to be human authorship for copyright protection. Another place that's helped, there's the couple of places here that you can go talking about public domain resources. These are, the publicdomainworks.net is an open registry of artistic works that are in the public domain. You can search by author or by title of the work. A lot of times here, like if we're trying to illustrate something, we have a lot of news organization things being gathered. We have a lot of people giving us material, but sometimes you just don't have what you're looking for. You just want something a little bit more to puff it up. This is a good website, www.publicdomainworks.net. There's also some calculators to help you figure out whether a work is still in the public domain, is still copyrighted or has moved into the public domain. One is Public Domain Sherpa, and the other one is copyright.cornell. I believe you have all those on your slides. The copyright.cornell I like a little better. I would not look at it just in a vacuum though, because it's a little confusing. If you actually have a work you're trying to look up, I think this one is sometimes a little clearer, and I think it gets updated more frequently. So I frequently have to remind people here that being on the internet does not make it in the public domain. In the public domain is a term of art. It's been used in the legal world for decades and decades before there ever was an internet. But the internet just makes it so easy to find things, grab things, reuse them, but it also makes it really easy to get caught. So just always remember that. It is not in the public domain just because somebody else put it up there. You really have to do a little bit of checking to make sure that what you're using is either not copyrighted, or their copyright has expired, or it is licensed under something like, you know, like if you have an app, if you have a license to use other people's work, musical work, some of those things, then you can use it. But you do have to do some checking. Okay, now for music. I had mentioned this earlier. There's two different components of a sound recording. The underlying musical composition and the actual sound recording. Now, I'm not sure, like we do a lot of broadcast here. We're also on the web. And that's why this is an important part of what I talk about here. If you're just writing things that never going near music, this may not be as important to you, but it's pretty interesting how it works. So the two components of the sound recording are the underlying musical composition. This, you know, the score of it written out on a piece of paper, available online or whatever. And then there's the actual sound recording. Each is protected by its own copyright. And in many cases, there are two separate owners. I mean, you've probably heard many songs done by one artist and then another by a different artist. And, you know, they both have their own copyright in the actual sound recording. And then it's also publishers and, you know, whoever, licensee, ASCAP, BMI. Music is a little complicated, so you do have to be pretty careful about that one. But you can find all that information by just Googling or Binging or whatever search engine you use, the particular musical recording that you're interested in, and all of that information will come up. The title, when it was published, who holds the license. It's pretty easy to find all that information out. So. But essentially, all sound recordings are under copyright protection. And just last year, there was the Music Modernization Act of 2018, which actually expanded many protections to recording artists. There was a gap in protection at one point where they were not really getting the full advantage of their sound recordings. A lot of it had to do with how they were played on the radio, and those have been fixed. The artists, I think, are pretty happy with the new act. So the sound recording copyright owners, they have full performance rights with respect to digital transmissions. They do not have the same rights for broadcast transmissions. That's part of the gap I was talking about. So streaming, downloading, and podcasting are digital transmissions which require licenses from the record companies and or the artist. That's where you have to be, sometimes if you're trying to put something together on your website and you'd like some background music, they will, if it's just on your own website, it may not be as easily or as readily detected, but if it goes out onto some other platform like YouTube, it will be detected very easily. Your organization may have a license for certain music rights, but unless they've all been updated recently, many of these licenses are for broadcast purposes only, and they do not allow automatic digital use. And that really has more to do with Facebook and YouTube and their terms of use than with with BMI or ASCAP. So that's a very difficult, that's a difficult way to try and follow it. But if you're going to use it in a digital use, you should actually get some assistance. And I'll talk about another way you can go about doing that later on. Okay, so Twitter, this is always new and fun. I'm guessing most of you have some access to Twitter. You probably maybe have your own accounts or at least watching what everybody else is doing. Sucks a lot of time, in my opinion, but it's a great resource, and you can get a lot of information very quickly. Whether it's all accurate or not is another question. But it's a really good resource and place to go for quickly finding out what might be happening. Much of what's on Twitter is too short or is lacking in creativity to be protected. When it was the 140 characters, it was a lot clearer. Now that it's a little longer and people are writing 1, 2, 3, 4, 5, 6 out of 10 posts, it's getting a little bit less easy to say that it's not protected. But in the beginning, there was really not too much protection afforded to what people were tweeting. But if someone tweets their own embedded picture or video, that will be copyrighted. So, you can like it or whatever, but don't take it off and use it as your own. There's a current case right now against Conan O'Brien over the use of, I thought it was 4 separate jokes, but when I just looked at it this morning, it's 5 now. There's another writer who had his own blog and also was on Twitter. And he had 5 different jokes. You can go look them up. I don't really feel comfortable talking about them here. It's not quite appropriate for this sort of seminar, but you could go look them up. The case is, you could probably just Google whatever Conan O'Brien and copyright case. But this writer had, over the course of a couple of weeks, he would put a joke on Twitter, and that next day or maybe 2 days later, it would either appear in Conan's monologue or as another part of the show. And he did, in fact, write to Conan and their company and say, hey, they're my jokes, take them down or give me credit or whatever. And Conan basically refused. So it's been in the courts for almost 4 years, and they just did a couple of filings in January. Conan's theory is, which I found funny, was he said that those jokes were just too unoriginal to enjoy protection, but yet he did in fact copy them. He said that it was negligible and trivial variations on unprotected ideas, pre-existing works, or public domain works. I don't really know. I didn't read the entire filing case history of it. But I do remember seeing one of the tweets, hearing Conan O'Brien's joke about, one of them was about Tom Brady and, thanking, I think, the coach of the opposing team for taking them across the line to win the Super Bowl. So it's kind of snarky, but I do actually remember that. That is one of the jokes that was in question. The judge threw out 2 of them, but 3 of them are still going forward. So we'll see what happens, and I'll have to keep updating my seminars here. And this isn't Twitter, but I just thought I'd throw it in here because it's other jokes. A lot of people have said for years, well, jokes, they're just not really protected because although they are, there is some creative process, they're short and it's just, not worthy of protection. The judge, not only in this Foxworthy case, but in other cases, another judge, they've gone through and discussed how a joke actually comes about and gets famous and the amount of creativity in it. So Jeff Foxworthy's, you might be a redneck if, they found that to be protected. And they, I think it was a pretty big award against someone who was selling T-shirts with that name. One of the rights of a copyright holder is to do whatever you want with that right you have, which means you can make adaptations from it. You can sell T-shirts. You can put it on, coffee mugs. That you can make money from it. So that is one of the basic rights that you have as a copyright holder, to protect your own material and for you to decide whether you want to make any money from it in these particular ways. This person said, well, he wasn't making any T-shirts, so why couldn't I? But that's not the standard that the judges are going to look at. It's what rights the owner actually has. And one of them is to make as much money or as little money as he wants. Okay, now fair use. This is always, fair use is a great concept, and it's frequently used by many. It's frequently used, and it's frequently used appropriately. When it's used inappropriately, it's basically because the person feels like, well, I'm not really taking anything from them. I think it's a fair use, and I'm not using that much. That's not really how a fair use question would be determined. You have to remember that fair use is a defense to a charge of infringement. So what happens is a copyright is violated. Someone has taken a copyright protected work and used it as their own without the permission of the owner. And so when that happens, the person says, well, it was a fair use. So the first thing is you're admitting that you did in fact take it and use it without permission. So because it's a defense, once you've admitted that and gone on, if the court finds that it was not a fair use, you've already admitted that you've taken it and used it without permission. So, most of the cases, our cases are not that big. They're not going to get that far. But in a lot of cases, it can amount to quite a bit of money. And like with some of the bigger media companies, I think the Jeff Foxworthy case was actually a pretty good one. And that was rejected there. So the infringement occurs whenever someone exercises any of the rights reserved exclusively for the copyright holder without their authorization. So the user is admitting that he used the protected work, and he or she is contending that it was fair use. But the fact that you believe it and the fact that you were using it with that in mind, that does not mean that the owner of the copyright agrees, and you or your organization could still be sued. There's no bright lines in fair use. I hear very often, well, I know you're allowed to use 10 seconds and I only used 8. That, that is kind of a common perception. It's not, I mean, I guess you could kind of use it as a rule of thumb, but I would not rely on it because it is not actually the law. Each case must be determined based on the specific facts of the use and the unique nature of the work. It's a balancing act between the interest of society in being able to use information and the rights of the creators to be able to protect their own intellectual property. The 4 factors that judges consider in determining whether the use is fair are the purpose and character of your use, the nature of the copyrighted work, the amount and substantiality of the portion taken, and the effect of the use upon the potential market. So the potential market, that's more pretty much what we talked about with the Jeff Foxworthy thing. So that's one thing. The others are all those rights you have as the holder. I mean, in your works that you create, you are the holder of those works or your company. So you get to have that protection as well. So when we talk about the purpose and character of the use, including whether it's commercial in nature, a commercial or non-commercial use, and whether the user's making any money from it. When you use the nature, the nature of a copyrighted work, a book of quotes will be protected, maybe because of the way that the editor has decided to put all the quotes together, but it's less like using a couple of quotes from part of it is not nearly as egregious as using a poem. That's where there's a lot more creativity involved, rather than just, putting all these quotes talking about, I don't know, the ocean into one section. I mean, that has some creativity, and I mean, there are many edited books that are really very creative, but many times where it's just a basic fact book, the level of protection is not quite as strong. If you're using a copyrighted work and adding something to it, that puts it into a different category, and that's a much better way to go about it. So the other things are the proportion of the work that was used or taken. So back to the 10 seconds that people frequently tell me, like if you take 10 seconds of a 2-minute song, couple of minutes of a 30-minute TV show, it really depends. If you can take 10 seconds of a 2-minute song and you're probably going to be okay if it's not something that is so distinctive in that particular song, that this is the absolute essence of that song. The same with the 5 minutes of a 30-minute TV show, in my opinion, would be way too long. Then the final thing is the economic impact of the use or the taking. Has the creator or owner been deprived of a profit or opportunity to make a profit, whether he intends to use that or not, whether he intends to engage in that particular activity or not, is of no interest to the judge. Okay. Generally, fair use will be permitted for criticism, comment, news reporting in some instances, teaching, including multiple copies for classroom use, and research and scholarship. So for criticism, if you are a book critic, a movie critic, a TV critic, whatever, and you have quite a bit of leeway if that's your particular field in using things and then providing a critique about them. It's understood that your job requires that you take the writing, you take the piece of art, you take the part of the TV show, and then you add criticism to it. I mean, you critique it as either really well done, awful, whatever. That's your job, and that's acceptable. Same for commentary. if you are discussing some things in the news, you know, talking about new fashions or new trends, you can take people's works that are out there that are copyrighted and say, look, this is how this particular subject is trending. This is their view of it, someone else's view of it. And you can use all of those things despite the fact that they are copyrighted, because what you are reporting is, or what you are commenting on is what is the trend. Similar to criticism, but it's not quite as clear. Well, that's not true, it's very clear, but it's just you have a little bit more leeway on that. News reporting, you know, you could say the New York Times is reporting la, 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 but you have to be careful about that too, and kind of not use, I guess I should have said the Chicago Tribune, I'm sorry, not use more than you need to get what your point across. So teaching and including multiple copies for classroom use. This is basically when people used to, and this is actually becoming a bigger problem now because of the ease of finding things on the internet and the ease of copying. But, you know, professors used to take an article or maybe short excerpts from a play, make a couple of copies and hand it out to their class. So that was always considered okay. Now there's some question. Some professors are just putting up a link or putting up parts of what normally would have been a textbook that their students would have been required to buy, and just putting it up there. And that is not, they're having some difficulty with that. I think they've gotten it pretty well worked out, but that is not considered including multiple copies for classroom use. They really were talking about paper copies that you've done at the machine. And research and scholarship, that comes back also to like criticism and comments, where professors or doctoral students or whoever, you know, wants to write books, and they can show, you know, this is what this study did, and, you know, quote large portions of the study, put it in there. But you do always need to have appropriate attribution on any of these things that I've just said. It's fair use, but you should always attribute it appropriately. Okay, two other interests are important to consider. The first is the intent of the user. Although infringement does not need to be intentional, the motive and intent of the user will be relevant. If someone's using it, you know, money is usually one of the biggest things. If somebody's taking somebody's art and using it to make money, that's bad. There's also some First Amendment issues that pop up on occasion. Facts which can be known or found out by anyone cannot be protected. Even in a news story, I mean, a second reporter can use the same facts. How those facts are presented are different. But, you know, sometimes facts in news reporting, and the same in business reporting, I mean, the facts are the facts, and there's always so many ways you can say the federal government reported out today that, whatever. It's, you know, you do have some leeway there because you want to present those same facts, and unless it's really creatively presented, which is not always the case in news reporting, especially quickly on issues, it's, you know, you can't really hold someone. The first reporter is not the one that gets to hold the entire facts of the story. You can't copy the story, but you're entitled to use those facts. Okay. So just to recap, whether it's a commercial or non-commercial use, does your use fit the purposes for which fair use, the exception, had been recognized? Is your use transformative? Have you taken something that someone else has copyrighted and transformed it into something else? For example, a musical remix, a satire of the original, a parody. There's a show out, oh, I can't remember, Parody Up. I don't know whether you're familiar with it or not. It's very funny, but they take whole movies basically and make a parody of it as a documentaries up, I think it's called. I shouldn't have talked about that because I couldn't remember. But, a parody, you have a lot of leeway to use quite a bit of the original, because the purpose of it is to parody the original. So people have to recognize that it is, in fact, part of the original. Satire is not considered quite the same. You get a little bit, you only need a little bit of the original for satire. But just remember, there's no hard and fast rule. The law does not specify an absolute ratio, and you should always use no more than is necessary to achieve your objective and attribute it. So, for example, a still from a movie, even a very popular movie like this, using that, writing about it, even sort of in a satirical way, or just say, hey, look at this great picture, but it's a still from a movie, you're probably okay. Probably not fair use is a 1 minute of a recording. Music videos are very difficult. I would really not use those without some expert advice. And famous photographs. Now, some companies are a little bit more diligent, shall we say, about protecting their copyright. In that category, I would put Disney. I would never use anything of Disney's without their permission. They can find you. I mean, they're very good about protecting their things, unless it's a parody or transformative. Now, this next one, this is Disney Mickey Mouse as Chairman Mao. This is perfectly acceptable because they took the Mickey Mouse protected work and they've changed it into a transformative figure. Our focus here is on Asia, and Xi Jinping, their internet is very censored, and a lot of outside publications are not available in there. Facebook is not available. But the Chinese that are very clever in coming up with different things. And at one point, someone had noticed that Xi Jinping looked a little bit like Winnie the Pooh. So Winnie the Pooh was all over the Chinese internet for a day or two. But Chairman didn't care for that. So Winnie the Pooh came right down. But now I see here in the United States, and it won't be seen in China, but maybe some in Hong Kong, there are a lot of transformative uses of Winnie the Pooh looking like Xi Jinping. So they're sort of they're ways that you can use very popular, highly protected works in a transformative fashion. Olympic rings and Olympic music, they are a definite no-no also, in my opinion, because they are very well protected. And their protections, the Olympic rings, I mean, the music's by statute. So you need to be very careful unless you are actually part of a company that's covering the Olympics and has the rights to use those. However, like when my people were in Beijing covering the Olympics, I would suggest if they were, they could stand in front of the big Olympic rings to report. So, but you couldn't use things that we couldn't put these Olympic rings on our website. So you need to be careful about that. The same with the music. So, I want to talk a little bit about YouTube. Because of the digital directors, I don't know whether you all have a digital director or you are your own digital director, but a lot of this is specifically for digital, but some of it is still what we've already talked about. There's no magic number for fair use. Using 30 seconds of an audio video, even if you're using it to support your work or support what you're talking about, it's still infringement depending on the context used. So, but YouTube's very good. If you go, there's a link there and it will tell you how they make some decisions and what you should be looking at before you use any of their works. Never post any raw video or audio, just throwing it up there. even without reporting on it or commentary. If you just put that up there, you know, you have no chance of it being seen to be fair use. If you can put up something and say, you know, this is what is happening, and this is why we're using it, you might have a better chance. But without some commentary or reporting to go along with it, you will not be found to be a fair use. It looks like you're just putting it up there because it's a great video, unless you have the permission of the rights holder. So now if you infringe a copyright on YouTube or Facebook, they have excellent algorithms, which you may already be familiar with, that it's very sophisticated, and content identification will automatically detect when any copyrighted audio or video is uploaded to their platforms, regardless of the duration of the clip. And so it will get taken down almost immediately. So there's another link there, gives you some explanatory information if you're trying to use something that you found on YouTube. If a user's caught uploading content claimed by other parties, or penalties can range from content being tracked to copyright infringement notices that can remove functionality from your social media accounts. Twitter, I should have mentioned this when I did the Twitter. Twitter will also take down tweets that they have been notified are infringing. I have not seen that their software is as sophisticated. That they usually wait until there's an actual complaint. And repeated infringement can lead to termination of a social media account, which is pretty dangerous if you're in a company kind of like ours, because we have 9 languages. They all have their own different accounts. We work together as Radio Free Asia, but each account. And if one of those accounts is getting in trouble, then it could affect all of our accounts. So we have to be really, really careful with it. So, so you can get permission, and if you get permission, this is how you should go about it on getting your things onto Facebook or YouTube. Now, these are the technical, mechanical ways of actually doing it. This isn't really the law, but I thought I'd throw in there as much as I know about it. But we have a social media director who actually takes care of all this. So the first part is getting authorization from the rights holder to use the content. When we talked about the music, all that information is available. Maybe your company has a license to use it, or there is a contact the user. You can find other things on websites. Everybody has a terms of use. They will tell you how to get in touch with someone to ask, can you have the rights? You know, some organizations are pretty good about allowing you to use it. We're a nonprofit. We don't broadcast really in the United States. So sometimes, and we have a really great mission. So we sometimes are able to get rights for no amount of money. We aren't allowed to keep them forever, but we can use them for maybe 1 or 2 features. So then the user has to ensure that the automatic claiming system on YouTube and Facebook won't target you. So confirm with the rights holder that they will not claim the video on social media. Provide the link to the video so that it can be whitelisted, and then remove the content after the agreed upon period. So the key takeaways here are always try to get permission from the rights holder. As I said, there's a couple different ways to do it, and get the permission in writing. If the permission's obtained, make sure the video is whitelisted by the rights holder on YouTube or on Facebook, whichever is applicable. Provide the rights holder a link to your video, and only use third-party content when it's vital to a news report. Use as little footage as necessary to support your reporting. And never use raw video without editorial comment. So if you are your own administrator or editor, keep a close eye if people are working for you, and make sure that they're putting stuff up there that they have the rights to. So I think I'm running out of time here. So anybody have any questions?
Bernadette, this is Kim. We did have a couple of questions that came in.
Okay.
One was kind of a fairly specific question about your example with the Chinese, the Asian leader who had been, his image was kind of morphed with Mickey the Mouse.
Oh, yeah, that was Mao. That was Chairman Mao.
Oh, okay, because they were asking if it was...
Xi Jinping?
Yes, I'm not sure if I'm afraid to pronounce it, but whether it was Xi Jinping, the current president of China, or there's also Deng Xiaoping.
The former one, yeah.
The deceased one.
The Disney one, the one that I put up there was a Disney, that was Mao. That was Chairman Mao as Mickey Mouse. That's a pretty old one, obviously, because he hasn't been around for a while. But there's a lot of out there on Xi Jinping. Yeah, most of them with the Winnie the Pooh are very funny. If you have a chance to just kind of Google it and take a look at it, some of them are really, really very good.
Yeah, that was a great example. We had another question from a listener who is inquiring about copying photos for PowerPoint displays in a classroom. And he says no particular kind of photo. He's just kind of wondering, am I allowed to copy photos for a PowerPoint display, presumably perhaps in a journalism class? And also, is he allowed to print out PowerPoints and distribute them to students?
Well, I'm going to put my disclaimer in there again, but this is how I would approach that question. If you are taking a picture of, okay, say someone has given you a picture, or you found a picture that's of something, I don't know, maybe, the Washington Monument, but done by a very famous thing. If you want to use it to talk about the Washington Monument in some manner, I think you're perfectly free to do that. If you're using it just for, like, these are the sites of DC, you probably can still use it too. And if it's only going to be used in a classroom setting, 30, 40 people, you make a copy of it, that does come under what, the classroom educational purposes. They're less, and if this is a more stylized, like I used to have in one of my other seminars, the amount of creativity involved in a picture, like if somebody goes out and takes a picture of a bunch of tulips, I mean, not I couldn't, but most people can take a pretty nice picture of a bunch of tulips. That's not going to get as much protection as a stylized version with different light settings and that kind of stuff. But as long as you're keeping it in a classroom, I feel like it's, you probably have a pretty good case. Okay.
Great. Any other, let's see, more to our listeners. Those were the questions that we had at the moment. If anyone else has a question, feel free to go ahead and shoot it to us. We have just a few minutes, but we may be able to work it in. I don't know if you, I realize you probably have covered everything, Bernadette, but didn't know if you had any final points to make as we begin to wind down, and see if there are any other questions.
Let me see. Let me go back through and make sure I've gone through all my notes. So, with news reporting, as I said, when I found out that this was like a business thing, when I look at all the business things, like in the Wall Street Journal or New York Times, within their finance section, they do make great use of charts and graphs, and all of that stuff is freely available. I mean, unless they've taken it from and made their own chart from it. The government has really excellent resources for a lot of the things that I think business people report on. And, we do that here. Like if we need some maps, we can get something from, the different world books or what, not world book, but the one that the government puts out. I can't remember what it's called, but it has a lot of really great information, populations, and so there are resources that you can use without running afoul of a lot of the copyright law.
I know nothing. Whatever you guys want to do.
Bernadette, we did get another question here from a listener. They ask, what if the creator is not the rights holder? for example, if a journalist or a news organization gets permission from a singer to use his song, but the record company says no. Does that make sense?
Yes, it does. Well, that is a difficult one because the singer, like when the publisher, the record company is the one that actually does own those rights. So the singer no longer has the authority. The singer has given those rights to the record company. So it's the record company's decision whether to use it or not. And, you know, I don't know what the exact contract between the singer and the record company would be, but it might be that the singer does get to have some input into what the record company is going to allow or not allow. And, if they are, because it's really a question of royalties at that point and whose money is affected at that. If the owner of the rights is the record company, they don't want to let someone else use it in a way that's going to affect their income. The artist might say, oh, I really like this little company. I'd like to help them out. It's okay with me if they use it. But once they're with the record company, they no longer own the rights to that particular song or adaptation of it, the recording.
Call their PR person.
Okay.
I can try to call the firm that
I think
represents them
I think that's all the questions we have, and I know we're kind of near the end of the hour. So I guess we will begin to wrap up. I first wanted to thank you, Bernadette. This has been a great and very useful presentation. Lots of interesting topics covered. The Twitter information was very interesting in particular. So thank you very much for your time and for the expertise that you shared with our members today.
Okay.
We really appreciate it.
There's a lot out there, so it took me a little while to condense it. So I hope I got the big points.
Yeah, no, it was great. We really appreciate it. And so sincerely, thank you on behalf of Cebu.
My pleasure.
And to our members who are listening in, mark your calendars for the next monthly training session, which will take place at 2 p.m. Eastern on Monday, April 29th. And that will be on writing for millennials. And as always, if you have any suggestions about future training topics, feel free to drop us a line at cebu@cebu.org. With that, I think we will conclude today's call. Bernadette, thank you again very much. We really appreciate it.
Well, thank you.
Okay. Thanks, everyone.
Okay, bye-bye.
Bye-bye.